Okay. Mhm. Mhm. Are you Gerald Cervantes? I can't hear you, sir.
Can you hear me, Your Honor?
All right, I don't know who just spoke.
Can you hear me?
What is your name, sir?
Eric McCord Sr., sir.
All right, hold on a minute. I'm calling another case first. I just wanted to see who was on this device.
Yep, it's Eric McCord, Your Honor.
All right, I'm going to put you back in the waiting room now that I know who you
Okay.
are, and I'll bring you back in when it's your turn. Okay, Mr. Smith.
Yes, sir, Your Honor.
Okay. This is a matter of Cervantes versus Smith. I don't see, I'm sorry. This is a matter of Cervantes versus Smith. I don't have Ms. Cervantes present.
Okay,
Have you had any-
I talked to her this morning. We both went to the courthouse actually, and obviously they can't get in. So she called, or actually she texted me that more or less I don't know if you want to call her, Your Honor, on the phone. She couldn't figure out the Zoom thing, so she just said she wasn't even going to try. And
I can call her. That's no problem. Do you have a phone number for me?
yes, I do, Your Honor. It's area code 517-945-8640. Let me double check that. One second, Your Honor. 945-8640.
All right, I'll give her a call.
Thank you, Your Honor.
It sounds like your phone is ringing. You sure you gave me the right number?
Going off because it's coming into my phone and then going out back to you.
Please leave your message for
Ms. Cervantes, this is Judge LaFlamme. I'm trying to reach you for the court hearing that was scheduled for this morning. Mr. Smith is present. Since I can't reach you and since you're not present in the Zoom room, we'll have to proceed without you. Okay, Mr. Smith, you filed objections to the friend of the court's recommendation for custody of your daughter, Nova. And let's see. And apparently circumstances have changed since the investigation was done.
That is correct, Your Honor.
the temporary, the recommendation provided for the two of you to share custody, and apparently she's not been,
I'm sorry, Your Honor, I didn't
taking
hear
long.
anything you just said.
All right, I'll start over.
Okay, there it goes.
The temporary or the recommended order was that the two of you would share custody.
Correct.
And apparently she's not been sharing. You're the one who's had the majority of the child care responsibility.
Pretty much fully, Your Honor.
What have you talked to her with what she would like to have happen here?
More or less, she said that, hold on, I can read you the exact message. So before I do that, what I would like out of this, it's up to you, obviously, but what I would like to happen is not for her parental rights. I want her to see her daughter. I'll fight for it, whatever I have to do. But I feel as though I should have more or less sole physical custody shared with mother. Therefore, I'm making all the decisions for in regards to our daughter Nova. But I don't want mom to not have any. I don't want her to give up her rights per se. I just feel that I should have legal custody of our daughter. Like I said, once again, making all the decisions for her in her best interest. But back to the message. She's just going through things right now, and I understand because I have to. She said, but I'm just going to tell the judge that I'm drained and done, and you can do whatever you want. I give my verbal consent to whatever if needed. And then she said, I'm headed back home. I said, no, you're not giving up your rights. Join the meeting and we'll take care of it. And then she said, just tell them what I said. I'm driving. And I said, Alicia, come on, please. I said, did you do Judge LaFlamme's court, for the Zoom? And she didn't answer. She didn't reply.
So what you're describing for me, the way I would put it in a judgment, is that you are awarded sole legal and physical custody and parenting time at such times and places as the two of you can agree.
That would be excellent because I don't want to keep Nova from her mom. Alicia's a good mom. Okay. She's just maybe going through some personal issues right now. I'm not 100% sure what's going on because I really don't talk to her a whole lot now. After we seen you previously, about a month or two ago, everything started going great. She was seeing Nova. I actually had contact with her, we were doing stuff with our daughter, blah, blah, blah. And then, I know this is all I read. Anyway, she got a boyfriend. After she got the boyfriend, everything kind of just fell off all the way. So, it is what it is. There's nothing I can do about it. She has to make her own decisions in life, just like we all have to. But I don't want to keep Nova from her mother in any way, shape, or form.
All right, so here's what I'm going to do. Based on the fact that you read to me exactly what her wishes are, I know what those are now. And from what you're telling me, I think probably the most expeditious way to do this is that I put a permanent order in place, as I've indicated. You get legal and physical custody. Mom gets parenting time, as the two of you can agree. And she has an absolute right. If she reaches a point where the two of you cannot agree, she wants to see your daughter and you're not letting her see her daughter, she can file a motion to get a specific parenting time schedule. So the door's not closed for her.
Correct.
As long as the two of you can agree, that works. If you can't agree, she's got the ability, as do you, to get a set schedule. I will I will grant your objections based upon the change in circumstances, and I will issue a final custody order that reflects what I've said this morning.
Your Honor, I have one more thing I would like to address with the courts in regards to child support. I do not want any child support from her. I'll pay the state costs, all that myself. I don't need anything from her. Like I said already, she's going through her own thing right now, and I'm fine with that. Nova's just fine. She'll be taken care of just fine. I don't want her to have another burden on her shoulders right now to deal with. So I don't need no child support. And whatever the state costs are for Nova's insurance and whatnot, I'll take care of that.
Is Nova's insurance is Medicaid?
Yes, until I just started a business last year and I'm trying to get everything in order with this tax, with last year's taxes. Once I do that, I'll either work out something with the state of Michigan or I'll just get her own insurance through my company. But I can't do that currently until I find something about filing my taxes and all this and that, I guess. I don't know. But as soon as I get that in order, I'll take care of it. But I know that there's going to be costs through the state and whatnot for Nova's Medicaid. So I don't want her to have no burden. I'll take care of all that myself. So I don't know if you're able to put in a zero support order for her. I don't want her to have to worry about it. I'm fine with that.
All right, I'll tell you what, I will look into, I mean, it's complicated by the fact that the state is entitled to obtain reimbursement when it provides welfare benefits on behalf of a child. I'm going to have to look into whether and to what extent I can do what you're asking. If I can, I will do it.
Or even if you can just leave it like it is, I don't even care. I'll just go down and pay it under her name. It don't bother me one bit. Either way, I have to go down there.
Well, I mean, you can always pay that child support obligation. I can provide that zero support is to be paid to you. And if you want to choose, sorry, I just saw a phone number log in.
I did too. I did put up on my screen as well.
I want to see who that is. Give me just a
Okay.
moment,
Yes, sir.
just in case it's her. I just let someone in with a telephone ending in 7770. What is your name?
Hi, my name is Julie Shotwell. I was trying to connect through Zoom on my laptop, but I wasn't being let in. I didn't want to miss the meeting.
I haven't called your case yet, ma'am. I see
Oh,
you in
okay.
the waiting room. As soon as we're ready to hear your case, I'll let you in.
Okay, thank you. I wanted to make sure that I wasn't having a bad connection. I can hang up this call and keep waiting.
Why don't you do that? If we have problems with the other connection, I can always connect by phone.
Thank you.
Welcome. Okay, that wasn't her, obviously. Okay, I will look into what is the best way to do that. I will prepare and sign a final judgment custody order as I've indicated on the record.
Yes, Your Honor. Thank you very much.
You're welcome. Have a good day, sir.
You as well, Your Honor. Have a blessed one.
And let's record versus record.
Hello?
Hello, Mr. McCord. We're waiting for Heather's connection. Looks like she's here now. Can you hear me, ma'am?
Okay.
Good morning.
Yeah, I can hear you. It's kind of low, but I can hear you.
All right. So we're here today on Heather McCord's motion for the court to set aside an ex parte personal protection order that was entered, well, it looks like back in December 14th. Ma'am, you would like the court to set aside this PPO?
Yes, sir.
So, I always want to make sure that we have a healthy situation here. So I'm going to take just a little bit of testimony. Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, Your Honor.
All right, so Ms. McCord, what is your relationship with Mr. McCord?
Okay. My relationship with my husband is good most of the time. A lot of our issues that me and Mr. McCord have is financial issues. It's not nothing more than that. We have a lot on our plate. A lot has
Let me
taken
stop.
place.
Let me stop
and
you for a minute.
I'm sorry. What was that?
I was asking a very preliminary question. So the two of you are married,
Yes.
Yes,
but apparently you live at separate addresses?
Yes. Right now,
yes.
yes.
Okay. And you tell me why you would like me to lift this PPO.
We have 4 children that are disabled, and I have appointments left and right with them with therapies, doctor's appointments, and so on. And I'm needing his help because I don't have nobody else to help me outside of him. And I would like to reconcile this with him without authorities being involved. Like I said, I really need his support and help with the children.
Okay, well, I appreciate that. It looks like there's been a lot of emotion and anger involved in the relationship between the two of you. But the
Yes,
thing that
sir.
concerns me most from your petition was an occasion back in July of 2018 when he choked you, took your phone, and pulled a knife on you.
He didn't. The knife part was a incident with my dad outside of my home. It wasn't. The knife part wasn't with me.
All right, well, in any event, going back to July of 2018, it does certainly show that Mr. McCord was violent towards you. Has he been violent towards you at any time since then?
No. It's more of
Uh,
words verbally.
All right. Well, let me tell you both that despite the little rhyme we used to learn as kids, sticks and stones may break my bones, but words will never harm me. Words may not harm you, but I guarantee you those angry words in front of your children harm them. That's something that you need absolutely to protect your children from. I'm satisfied based upon what you're telling me today that you're not in any physical danger from Mr. McCord. I'm going to grant your request and set aside this PPO. What I want you both to understand, especially if you've got kids that have special needs, you absolutely need to keep your disagreements away from them. They don't know how to process stuff like that. And it can be very damaging to young children to be exposed to that. So I'm granting your request. I hope you take to heart, both of you, for what I've had to say here this morning, but I am going to set the PPO aside. Did you have any questions for me, either one of you?
No.
Oh, just thank you, sir. And I absolutely agree on with what you said.
All right, well, good luck to both of you.
Thank you, sir.
Thank you, sir. Have a good day.
Have a good day. Yes, there is. Okay. Okay, this is the matter of Shotwell versus Lane. Ms. Shotwell, you need to unmute your microphone.
Can you hear me?
I can now. Were you successful in publishing notice of this hearing for Mr. Lane?
Yes. They said part of the fee I was paying for is that they would file the correct paperwork so that you could see that I had published that notification.
Well, it hasn't made its way to the file. Do you happen to have with you proof that the notice was published?
It was emailed to me. I can,
It's possible for you to do what's called a screen share. You look at the bottom of your screen, you see where it says share screen?
yes.
So open up the email that you're referring to. Once you have that open on your computer, then go down here and hit the share screen, and it will let me see what's on your computer.
Okay. So, okay. So I have two attachments here. One is the copy of the legal news that it came out, and then the other is the affidavit from the people who arranged it for me.
Okay, open up the affidavit if you would, please, and then share the screen.
Okay. So let's see.
Peter?
The affidavit's opening, but it seems to be stuck on the share.
All right, well, make sure it's open first, and then
Right.
do the share screen.
Okay, let's try this again. I can see it. Is it showing for you?
No, you have to share your screen. Go down to the bottom. You see that command?
Yep.
Click on it.
Yeah, I have it up. I have a little window that says share application, and when I hit the
Then
share
hit the
button, yep, I'm hitting it and nothing's happening.
All right, well, let's do this. I'm gonna have you forward that email.
Okay,
Are you ready? I'm gonna
yes.
give you an email address. It's R LaFlamme, just like my name is spelled.
Okay. Give me just a second. I'm hitting forward right now. Okay. R LaFlamme. Okay, I have that.
At mijackson.org.
Okay.
Has it been sent?
Yes, I hit send. Did it come through?
All right, I'm checking. It hasn't yet, but sometimes it takes a moment or two. Yes, here it is. So let me open this up. Okay, I see the affidavit. A little closer look at it. Very good. That's exactly what I was looking for. Okay. Let me take some testimony from you. Get to the right screen now. Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth. So help you God?
I do.
State your full name, please.
Julie Christine Shotwell.
Ms. Shotwell, what was your relationship with Stephen Lane?
He was my longtime boyfriend, and we lived together for over 20 years.
What is it that Mr. Lane has done or is doing that causes you to seek a PPO from this court?
Okay, so I don't know if you have access to my previous filing. I originally filed a PPO before COVID, and at that time he was still living under my roof, and his behavior had become erratic and aggressive, mostly when I asked him to move out, as I had broken up with him. And at that time, when he was still living under my roof, what he did was that he was bullying me, but he was physically intimidating. He never touched or hit me, but he would get really close to me and corner me and follow me around the house and yell at me. He's also made verbal threats. Some were just like he threatened to sue me for palimony. He wanted me to pay him for being in a relationship with him. But he also made physical threats, telling me that he had friends that wanted to hurt me. And the only reason they weren't hurting me is because he held them back and told them not to.
So at some point he did move out. What has he done since he moved out?
So directly after he moved out, I made it clear to him that he was no longer welcome on my property. I asked him not to contact me, and he showed up on my property a number of times after being told clearly not to. And it wasn't until I called the police that he stopped parking and coming onto my property. But well, he did again in December. He drives by my house every day, several times a day. I just saw him yesterday. He drives by my house a lot.
So Ms. Shotwell, I'm satisfied based on your testimony that Mr. Lane has engaged in what we consider stalking behavior. You've asked him to leave you alone, and he's not doing that. He's continuing to come by. And clearly this is distressing to you. I believe that a PPO is warranted. I'm going to issue a PPO. I will do that right now.
Thank you.
And we'll make sure to get a copy. If you were to violate the PPO, one of the things you can do is call the police if he's present on your property. If it's a matter of he's already, come by or keeps driving by or keeps calling you or doing anything that the PPO prohibits, you can file what's called a motion for order to show cause to hold him in contempt for violating the PPO. We still have to be able to serve him in order to get him in front of me to deal with it. But at least if he should appear at your home or in your driveway and the police find him there, they can arrest him on the spot.
Okay. Yeah, yes, thank you. I am working on trying to find a way to have him served. Yeah.
Well, if the police come and he hasn't been served, they will notify him that there's a PPO, and that's sufficient. They won't be able to arrest him that time. But if he comes back after that, they'll be able to arrest him just based upon them informing him that there's a PPO in place.
Okay. Thank you very much. I think this will give me some peace of mind because it's been hard having the police come out to my house and telling me that they can't do anything. And I know that's not their fault.
Well, this will change that, ma'am. So I hope he gets the message and he leaves you alone. I wish you well.
Thank you very much. How can I pick up the copy in order to?
It'll be sent to you.
Okay. And then that's what I can take to a process server?
Sure. But I mean, the fact that you're having trouble finding where he lives, that's going to be challenging.
Yeah.
But like I said, once the PPO is issued, as soon as the police have an encounter with him, they will inform him that there's a PPO in place. And if he does anything further after that, that'll be sufficient to allow them to take action to arrest him and bring him before me. Okay?
Thank you very much.
You're welcome, ma'am. I wish you well.
Thank you. Have a good day.
Okay, let's see. Looks like we're ready for Mary versus Warner. Good morning, Mr. Rosenthal.
Good morning, Your Honor.
And let's see, you are Devin Warner,
Yes, sir.
and Mr. Way is present on behalf of the petitioner. Do we have, I don't have the petitioner present. Mr. Way, have you had contact with her?
I have not, Your Honor, but Mr. Rosenthal and I did speak. Mr. Rosenthal and I did speak earlier this week, and we agreed to a resolution, basically an admission to some sort, like a technical admission type where we just warn and or sentence to time served because the context, the violation is not very serious, and I believe it's the first instance.
Yeah, Your Honor, it's my understanding that the petitioner actually contacted my client, asked him to meet out at the park. He did that. I have since explained to him that a PPO means no contact. He understands that unless it's dismissed and he has proof that it's been dismissed. He knows that it was just a situation. She called him up. I didn't really think about it because it wasn't him contacting her. Met her at the park. I think the cops were doing a walkthrough, saw them there. There were 2 cars there. He was there in there with her. And as a result, that's how this violation came about. He understands no contact means no contact. So we believe that that resolution is appropriate.
All right, and I have a specific memory of when I arraigned Mr. Warner. It seemed very clear to me at the time that that's why I released him on a personal recognizance that clearly, even though it is a technical violation, he wasn't doing any harm, he wasn't harassing, he wasn't threatening, and unfortunately ended up getting arrested. So I'm content with that resolution. So Mr. Warner, I need to ask you to raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
Devin Michael Warner.
Okay, so I should have had this open. Do you understand that you are pleading guilty to violating the PPO?
Yes, sir.
You understand that you are giving up the right to a hearing and the right to an appointed attorney to represent you throughout that hearing?
Yes, sir.
You understand that throughout the hearing, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, sir.
You understand that you have the right to have the witnesses against you appear and testify in person and to ask them questions?
Yes, sir.
You understand that you have the right to ask me to order any witnesses you would have to appear and give testimony at the hearing?
Yes, sir.
You understand that you yourself do not have to testify and nobody can say anything about you not testifying or hold it against you?
Yes, sir.
You understand that you also have the right, if you choose, to testify at a hearing?
I do, sir. Yes.
You understand that if I accept your guilty plea, you will not have a contested hearing. You will be giving up all the rights that I've just told you about. And you'd also be giving up any claim that the plea was not your own choice, but the result of promises or threats that were not disclosed to me.
Yes, sir.
You understand that the maximum penalty for violation of a PPO is up to 93 days in jail and or a fine of up to $500.
Yes, sir, Your Honor.
You understand that any appeal from a conviction and sentence following your guilty plea will be by application for leave to appeal and not by right.
Yes, sir.
You understand that if you are on probation or parole, the plea could affect your probation or parole status.
Yes, sir.
Has anyone threatened you?
No, sir.
Other than the recommendation that I sentenced you to time served, has any other promise been made to you?
No, sir.
Tell me, how do you, is it your choice today to plead guilty?
Yes, sir.
All right, and tell me, how do you plead today to violating the PPO?
Guilty.
Mr. Rosenthal, could you please establish a factual basis for the plea?
Yes, Your Honor. Mr. Warner, do you recall an incident on January 14th of 2021?
Can you be more specific, please?
At some point in time, did you have contact with, I believe her name is Mary, is it Mary? Marry?
Yeah.
And she had contacted you
Yeah.
and she had actually asked you to meet out at the park or something like that, or you guys got together and met at the park?
Yes, sir.
And you understand you had a PPO in place at the time?
I apparently had been it had been presented to me, but I
Okay.
honestly,
Right, but you understand there was a provision that you were supposed to have no contact with her?
yes, yes, sir.
And you understand that even if she initiates contact or anything like that, you understand that's a violation on your part with regard to a PPO?
Yes, sir.
Okay, and you did have contact with her because she called and you met her at the park? Is
Yes,
that
sir.
correct? Okay. And that happened on or about January 14th, is that correct? 2021?
Yeah.
All right, thank you. I believe this plea has been understandingly, voluntarily, and knowingly made, and that Mr. Devon's, that's his first name, I just put it aside, that Devon has made a knowing, voluntary plea. I'm satisfied with it. And I'm going to sentence him to the time served when he was arrested at the time of the violation. So Devin, you know, until this PPO is gone, stay away from this gal.
Yes,
Far
sir.
away as you can.
Yes.
She's already cost you a day in jail. I would say she's not worth it.
You are definitely right.
All right. We're all set. Have a good day,
Okay.
sir.
Thank you very much, Your Honor. Good
Thank you,
luck,
Your Honor.
Devin.
You're welcome.
Take care.
See it.